Today, we've got an exciting topic to discuss. I'm Bill Gentry. Now that we're finally getting to the other side of the COVID pandemic, those of us working in the judicial system have to figure out the best way to move our cases forward. Now, by law, courts have to deal with the huge backlog of criminal cases that have essentially been frozen along with civil cases since the Georgia Supreme Court declared the first judicial emergency over 13 months ago. All of the other types of civil cases, including divorce and custody cases, will necessarily have to take a back seat in the process until the criminal case backlog is taken care of. One of the alternatives that family lawyers like me looking at to move our cases forward is to do private arbitrations outside the judicial system to serve in the role of a judge. I've got a great guest with me today to talk about private arbitration as an alternative to the formal arbitration process. Judge Jim Bodiford. Welcome, Judge Bodiford.
Thank you very much. I'm honored to be here.
Judge Bodiford retired from the active bench in Cobb Superior Court in 2015 after 30 years of service. He still serves on a regular basis at the courthouse, helping with the caseload as a senior judge. Judge Bodiford is probably best known for handling some of Georgia's highest profile cases during his career and winning high praise from court watchers for his control and fairness. In retirement, Judge Bodiford has built a robust private alternative dispute resolution, or ADR practice, helping people stay out of the courthouse and avoid the cost and inconvenience of a full-blown in-court trial. Judge Bodiford is much in demand as an arbitrator and mediator because these processes help the parties resolve their cases faster, and it can give them more satisfaction than the traditional trial process. Judge Bodiford, before we delve into this topic in more detail, is there anything you want to share with our viewers about your background or your current ADR practice?
Bill, thank you so much for having me. I'm enjoying a retirement that basically I'm working full time. And my wife said, when are you going to stop working? I said, when I stop enjoying it, and I'm enjoying it immensely. I've had an opportunity now to do many things, including being a judge for 30 years, but I've enjoyed all of those, all of my roles, but perhaps this was the role that was designed for me at the end of my career, and that is to take my experience and to help litigants, to help people just like me stay out of the court system. And because nobody wants to go to the courthouse except Bill and I and others that have a special badge, and we know everybody. It's sort of like I think of myself as I don't want to go to the hospital. If you have to go, then you need to go, and there's some good people there to help you. But I want to stay out, and that's what I've been doing, and I've been enjoying it. And arbitration now has become much more a part of my practice. So thanks for inviting me.
Great, great. Well, Judge, I know that there are different types of ADR. And for those who may not be as well versed as you and I are, can you talk with us about mediation, arbitration, and the other types?
Mediation is, I like to think of it as me being at home and being with my wife, where I have no power in mediation, even though I'm a retired judge. Basically, I have the power, hopefully, of persuasion. I have all the experience that I bring to mediation, and I work with some very good lawyers to try to help the parties reach their own conclusion. There's the second type, which I think we're going to talk about here today, is arbitration, which is more what I did for the 30 years. And that is, I like to laughingly say, bark out orders. Obviously, in private mediation, I don't bark them out, but in an arbitration, I have the final say. So that is, and obviously everybody goes in eyes wide open. They know that I'll have the final say, and it's much more like a trial, but it's typically more relaxed. And we'll be talking about, I think Bill is going to be talking a little bit later about some of the huge advantages to our private arbitration versus coming to the courthouse.
Now, there are some other types of alternative dispute resolution. For example, I've done one or two, it's been a while, case evaluation, things like that. Do you ever engage in these other types?
I do. So sometimes we try to basically combine them with, say, a mediation. So if I went into an office where we have a couple getting a divorce, both of them have their lawyers, they're in separate rooms, we'll try to mediate the case. But if it looks like maybe by the end of the day or whenever quitting time is, if we're not going to reach a decision, uh, if uh, if the lawyers ask me to, and we sign some special paperwork, it doesn't cost any more money, then I'll give them some thoughts about what I think about the case. I don't tell them what their judge will do because I don't know, but I can tell them my thoughts, which sometimes help. I'm told by lawyers, which sometimes help their clients, the parties, resolve the case after I leave.
Gotcha. Well, let's talk just a little bit more about mediation before we get into arbitration. Now, like you said, it's like being at home. You don't have any power, but other than I guess what they call the bully pulpit, right?
The When I'm invited into the office, they obviously I'm bringing. It's not my good looks that people are inviting me in. It's my experience, and plus now I found I have a real love for mediation. I was involved very early in Georgia's uh, uh, when we began the ADR, or alternative dispute resolution. And I was involved really as a lower court judge. I was the president of our organization throughout the state. And I sat at a big table with some important people, and then I was there. But we gave away a lot of money in the 90s at the very beginning, and I learned about it, and it's been hugely successful. It keeps cases out of the court. And it was very important before COVID, and now it's going to be so important because our chief judges are telling us that it might be 2 to 3 years before we're able to clean up the backlog. So I've never seen it like this. This is actually my 37th year as a judge, 7 years now serving part-time in retirement. So we need everything we can get. But by the way, when parties mediate and they reach a settlement, often they do, sometimes they're not high-fiving each other or high-fiving me, but it's a better result than the unknown of going in front of a stranger. As smart as the stranger might be, that is the judge, as smart as the stranger might be, if you're like, probably Bill, I know you're like this, I'm certainly like this, I want to control everything I possibly can. If I could control traffic in the morning, I would. So this is a way you can control your own case. I often tell people when I'm in court as the one that barks out orders, remember, you asked me to do this. So at the end, I will make what I believe that is a reasonable ruling, certainly based upon the law. But if you don't believe so, obviously you have the right to appeal. But remember, you're the one that asked me to do it. The mediation is highly effective. It's worked great. It's worked great in Georgia, and it continues to become more and more popular.
Well, it's interesting because a couple of sayings that I've heard other judges say, one of them who's retired and deceased now would say, I may take a day, a week, a month, or a year to hear your case, and I will never know as much as you and your spouse know about this case. So I could never craft a resolution that's as good as what the two of you, the parties, could craft on their own.
You're exactly right. I often tell people, for instance, in custody cases, which is one of our toughest in my career, the toughest cases I had were many, many custody cases and death penalty cases. But I would say when I first met the parties that were going to have a custody fight, I would say to the parties, I don't even know your children's names, and I would be impressing upon them about why they would trust this huge decision to me, a stranger. And immediately one of them would always say, and it was not a trick, but you knew it was coming. Some of them would automatically say, "Oh, it's James," or "It's Jane," or whatever. And I said, "That's not the point. You're asking me, you're trusting me." And I said, "I appreciate it. I know I'm sitting up higher and I have a robe and this is very formal. but don't expect me. I have a lot of training in this area, but how about if I get it wrong? How about if I get it wrong? And what I'd like to say, and I don't mean to be mean about it, but once I finish the case, I'm finished with it. I'm on to the next case because we have hundreds of cases. I'm on to the next case, and you have to live with my decision perhaps for the rest of your life. That's one reason why mediation is so very effective. And we can often do this. Let's say in a custody case, if you have a true custody case, you go in front of a judge makes a ruling. Are the parties going to be more than likely to basically get along after that? When you look at the alternative, perhaps they make a compromise at a mediation, then they may very well have made their first compromise they've made in months. And hopefully that they can build on that. And that's what the child needs. Now, I know I'm in a little way, I'm arguing against arbitration there, but at the same time, if you can mediate your case and resolve it without somebody with the experience I have or whatever involved in your life, you are much better off.
Well, and I think the point, and we're going to talk about this more in a few minutes, but that arbitration is a kinder, gentler way to try a child custody case that can't be resolved at mediation.
You're exactly right. If you have to try your case, and we have some individuals, for instance, that absolutely believe that they should be the primary parents, and when we get two of those, and they both may be good parents and they have different reasons. Certainly, you would want to try it if you would certainly want to, number one, pick your own judge. You can do that in arbitration. Both sides would have to agree. And then two, pick your own date and pick your own venue and not have the judge not have 20 other cases on the docket that same day. I used to say to Nancy, my wife, I would come home about 6:30 and she said, "How was your day?" And I said, "It was great. I did a lot of work." I said, "There's no one in the courtroom that would argue that I didn't work hard." But I said, there were 4 cases that I didn't get to. And it's almost like lining up for surgery and then you never got to them. It's not because you didn't work hard. I said, I don't think those people are happy at all. And I don't blame them. If we could know the exact number of cases to schedule where nobody would ever be, anybody would be inconvenienced, that'd be perfect. So can you close that door for me?
Yes,
thank you very much. Thank you. So
well, you're in a working environment, Judge.
They are. That shows that they're, and I'm normally the one loud in the hallway where somebody goes, "Jim, we're on Zoom or whatever." But it certainly is better when you come in. I just finished a 4-day arbitration. Now, I've had arbitrations that literally lasted as short as 2 hours, and then I've had several that went 4 days. But in this 4-day, not one of these 4 days did they have to compete, did the parties or the lawyers have to compete with other cases. We started every day. Everybody agreed to start at 9 a.m. We started at 9:01. We were going, and we had decided among ourselves, we had decided when we would finish.
Right.
Typically you finish at 5, but sometimes we'd said we'd work as late as 7 if we needed to. Now, we were able to finish it in the 4-day allotted time. Whereas you may go in front of the courtroom in my former life there, you may go in front of the courtroom and the judge may hear something until 3 o'clock and then have an emergency at 3:30, or we don't get it done. And then you try to fit in the judge's schedule later on that month or 2 months down the road. And it's a kinder, gentler way. Now, at the very end, the arbitrator, different than the mediator, making that decision. You may not like the decision any better, but at least it was a little kinder in getting there. And I think one of the most important things is the people at arbitration. I say at the end, do you feel like you were hurt? Is there anything that we didn't get to? And arbitrations, I think everybody feels like they have been heard. Where in the courtroom, you know, I felt like, and I think most judges do this, they have to hurry people along because they've got folks standing out in the lobby waiting to come in and see them. And, you know, I used to joke about, well, I no longer, obviously, I'm still working on a limited basis here in the courthouse, but it was always hurry up, hurry up, hurry up. And, you know, as a lawyer many years ago, as a felony prosecutor and as also in private practice, I never liked it when the judge did that. And arbitration, typically that doesn't happen.
All right. And when you've got, well, in an arbitration process, because a lot of the rules, the formality, I guess, is more relaxed. I mean, you're going to take very seriously every piece of evidence that's brought in, but the parties can agree, or you can say, we're not going to be quite as strict on some of these rules of evidence as long as you're satisfied that the evidence that's presented to you is accurate and true. You can make it a little bit easier, which can actually reduce the cost. You don't necessarily have to fly somebody in from Washington State if you're a litigant or the lawyer. You don't have to. You can agree on certain documents that might otherwise require a whole lot of other folderol to get there, right?
Absolutely. What 100%. I've had some, typically lawyers want to follow the rules of evidence. And I understand that because that's what we've been taught our entire career. And we take refreshers on the rule of evidence. And when evidence, the codes change, we do that. But sometimes we talk about hearsay. Hearsay typically is a very complicated subject, or it can be. But it could very well be that in an arbitration, we're going to allow some hearsay in, and they just trust the judge to give it whatever weight it's needed. I mean, excuse me, whatever weight the judge or arbitrator determines to give it, maybe no weight at all. If you said, you know, Susie told Aunt Mary, and Aunt Mary told the neighbor, and the neighbor told me, if they agree to let that in, it comes in, it probably has no weight.
Right.
That typically in these type of arbitrations, there's a more relaxed standard. I have actually been involved, and I'm not a huge advocate of this, Bill, but I have been involved actually more and more with arbitrations that are somewhat like a mediation, at least where the parties are sitting. That is in different rooms, believe it or not. Now, typically in an arbitration, it's much like a trial. Everybody is there. So if witness A says something, everybody has heard it. Well, I think in some cases where the lawyers and litigants, their clients are satisfied, mom and dad or husband and wife are satisfied. They know everything about what the other side's going to say. Then mom and her lawyer might be in one room, and they may tell me what they want to tell me. And then I go into the other room, and if I think I heard something important, I might share it with them. You know, I probably would share it. Hey, they said, you know, he always comes late to pick up the child. That's one of their problems, and they can address it then. But they would then address it. That's not my favorite although I'm used to that in mediation. That's not my favorite in an arbitration, but if it makes people feel more comfortable, if they're more relaxed, then we want that. You know, we don't want them to be freaked out. And typically in a mediation, in a mediation and an arbitration, I ask if everybody can be called by their first name. So I might call Bill and just say, Bill, on behalf of your client, make your opening statement or whatever. And this is not where you stand up and go to a podium. You're sitting down and say, okay, Judge, I've never had somebody say Judge Jim, but I've always said to them they can. Judge Bodiford, here's what we're going to present today. We think that the division of the assets of this marriage should be 50-50. And they want it to be 60-40. And we're going to show you that that's wrong, and we're hoping that you agree with us. And then the other side gets up and said, my colleague Bill, he's a fine fella, but he's got it wrong this time, and I'll tell you why. But it works better. People are actually when we're on breaks in an arbitration or whatever, sometimes you see the couples actually out there talking together. Probably the nicest thing, and I'm probably talking too much, Bill, but what I think the nicest thing is, I have conducted arbitrations where we have ended up settling the case without me barking out an order, or at least settling some part of it. For instance, if one side says, person receiving child support says, I want $2,000 in child support, and the other side paying child support said, I'll pay $1,750. Well, it's probably not going to be a very hard decision for Judge Bodiford. I'm going to look at the law, but I might even say, hey, y'all are so close, do you want to just divide the difference? And just to get that issue off the table. And often they make decisions. They may not make all this. If there are 10 important decisions to make, maybe they've only made 4, but that takes those off the table, and they don't have to worry about the other 6.
Well, and it's interesting because talking about that, I've done a few arbitrations as well, and I had one with a private lawyer, not a retired judge, 2 or 3 years ago, and we got well into the case. I cross-examined the other side's expert. It was a custody dispute, post-divorce custody dispute. Honestly, I did a good job on the cross-examination. So the other lawyer said, let's take a break. We're going to go out in the hall. And we did settle.
Good.
So
you know what, you may have brought up you talked about hiring a private lawyer. You don't have to be a retired judge to be an arbitrator. And here's the sweet thing. When I retired as a Superior Court judge, I'd been the chief judge at one time. There were 10 judges. When your divorce case was filed in Cobb Superior Court, you didn't know which of the 10 you were going to get. Now, if you got Judge Bodiford, you might be happy. If you got Judge Bodiford, you may say, "Oh gosh, I don't like that." I don't like that. In an arbitration, you get to pick your judge. So let's say that both lawyers said, I think Judge Bodiford would be good. After all, we've seen him 1,000 times in the courtroom. We think he'd be perfect for this kind of case. We think he'd be fair. He knows the law.
And you've got a track record that people know about.
Right. Or you might say, if one person said, how about Bodiford? The other one says, I don't think he'd be that good in this case. And so I'm not going to agree to that. But you end up agreeing to your judge. You don't have that opportunity in court. You don't have that opportunity. So I think that might be the best reason to arbitrate. You get to pick your judge, and you're not bound by a retired Superior Court judge. You go to whoever has the training and experience that you trust. So I think that might be the number one reason why you might do it.
Well, and in fact, in this case I just talked about, it was in another county, so it was none of your current or former brethren on the bench, but it was one where both lawyers said, we do not want this judge trying the case. And so that's why we decided to arbitrate and went to a very good private lawyer. But I think the nice thing about picking a retired judge is that you do have a track record, a history that we know, and we've seen how you think, how you approach things, which I think is great. Because in this case, we both knew the lawyer somewhat, but we didn't know him well. And so it was a little pig in a poke sack kind of situation.
Sure. And that's great. For me, it makes me feel good because in 95% of the cases I do, whether mediation or arbitration, they have picked me. They want me. And that makes me feel good. About 5% of my cases, not arbitrations now, but about 5% of my cases are sent to me by judges, say in Fulton or Cobb or whatever. They're normally difficult cases. They're normally cases they want off their docket, and they're sending them to me. And they've called me and said, I don't ever want to see this case again. Well, sometimes they do, sometimes they don't. A judge can't do that in an arbitration. He can't say to the parties, or she can't say to the parties, you must go to arbitration with Judge Bodiford. They could send them to mediation or maybe a judicial evaluation or a case evaluation. But you have to agree, number one, to go to arbitration. And then you would agree on everything else. When is the arbitration going to be? Who is my arbitrator going to be? What venue are we going to use? Even to the hours. I like to do this. I like to say, and this, I don't want to criticize myself from the old days, but if I told some lawyers, if I said, all right, I'm going to get the order out by 20 days from now, I'm going to get the order out. Well, if I missed that deadline, my staff lawyer would call and say, I'm sorry, Judge Bodiford's going to miss the deadline. He had a big murder case, had 3 defendants. It went longer. We've got a new deadline. And hopefully we didn't extend the deadline more than once, but there have been times when we've extended it. So far in my 6 years and plus a few months, every arbitration I've done where I've said there's a deadline, I've met that deadline. And typically the deadline is a very short deadline, 11 business days after all the documents have been sent to me, these proposed orders, whatever the lawyers agree need to be sent to me, which we all agree to. So I've never missed a deadline. I know that I'm probably setting myself up. And I think that's good, because how do you call a judge's office and say, hey, you owe us an order? And you might get the staff lawyer said, I know we do, but you're 7th down in the queue, or 17th down in the queue. And we all know how busy the courts are, particularly now. We've got some very fine judges. I maybe with the exception of a handful, every judge I've ever met across the nation are conscientious. Now, some I might prefer some rather than others to go in front of, but they're all conscientious and they work hard. But some of them may not work as hard on your case as you want them to be. And if you're waiting, if you have a custody case and you're waiting 5 months for an order, that's not a good thing. And it's probably not a very good thing for the child either. Because if you had a situation, say back in January, and the judge hears the case in January, and if it's in June, you may have a totally different situation by that time. So I'm a big proponent of arbitration, but here's the nice thing: you will not go to arbitration unless both sides agree.
Can't be forced to it.
That's right.
Well, Judge, so I wanted to talk a little bit about COVID and so forth. And you remember, I think it was March 13th or 14th of last year when, and of course, the Georgia Supreme Court governs the judiciary, the practice of law in the state of Georgia. And Chief Justice Harold Melton issued the emergency order, I think it was March 14th of last year, almost completely shutting down the court system.
That's right.
And that created ripples throughout. And one of the biggest issues has been criminal cases. And I know as a Superior Court judge, you've handled thousands, if not tens of thousands of criminal cases. But it's my understanding that the law is pretty clear that says now that, and they've just lifted the jury trial ban, and we're getting back to a whole lot more judicial activity, but that judges have to deal with the criminal backlog first.
Well, there's no question that, and I know if you have a case, a civil case in our superior courts, you don't want to hear this. But let's face it, first of all, in criminal cases, the defendants have constitutional rights, and they've got a constitutional right to be heard, number one. And second of all, we don't want anybody sitting in jail. First of all, they're presumed to be innocent. And they may be innocent, or they may not be able to be proven guilty. But two, we don't want them to be sitting in jail, whether they're innocent or not, whether they can be convicted or not, and pay for it. So we've got obviously things have changed, and maybe you have some relaxed standards about bond, which may or may not be good. But the bottom line is the criminal cases are going to have preference. Now, that doesn't mean that you don't hear domestic cases, because we do every single day, but they don't have the same priority that they once had, and it will take a while. It's going to take a while to catch up. In the Cobb County Courthouse, the judges are very diligent, and they want to serve everyone. But when it comes, there are only so many hours in the day. There are only so many hours in the day. And if you've got a murder case where you've got 3 defendants sitting in jail, that's going to go before a custody case. each and every time it's going to go. So and you know what? We had some noise out in the hallway, and now I've got a phone call, and I just shut my phone off, and I apologize.
Not a problem.
I probably should have done that before. I had at one time, you live and learn, but in my 30 years in court, and I was really given a stern lecture about people having their phones go off in court, and mine went off, and my microphone was right there. And I said, please turn your phone off so you don't look like as big a fool as I just looked. And I said, by the way, if your phone goes off, you're okay in the courtroom today, at least one time. I had the bailiff take my phone away. I think I punished myself for the rest of the day, or rewarded myself without having the phone. But it's a tough time to get into court. It's a tough time. It's going to be better. In Cobb, we just had our first jury trial this week, but it was not unusual to have 7 jury trials just in Superior Court alone, 7 jury trials in 1 week. We just had 1, and that's all that was scheduled. We were just hoping that was done. I think it was completed. I don't know what the verdict was, but I think we actually completed it, which is good. They had done, I know the acting judges had done a lot of work to protect everyone, obviously the jurors, the defendant, the lawyers, all the staff personnel. But it's just a tough time to get on the docket, plain and simple. I wanted to bring up one other example. It didn't happen in this county, but it was an arbitration that I did, and it's been several years back, and it was a multi-day arbitration, and it involved custody and involved money and whatever. But they went to try the case. This was before COVID. They went to try the case in front of the judge. And the judge had said, hey, you have 3 days to try the case. And that indicated to these lawyers, very experienced lawyers, that those 3 days were their days. When they arrived, there were 4 other cases that had been told the same thing. And I'm sure it was an oversight on the judge, but can you imagine how upset it was? This was a case that needed to be heard, and we were able to schedule it, docket it about a month later on my docket, and have the number of days. And then shortly thereafter, they received the decision.
Well, it's always interesting when the court requests an estimate of the trial length, and the lawyers say, well, 3 days. And of course, experienced lawyers know that doesn't mean 3 times 8 hours. That means 3 times maybe 5 or 5.5 hours, because, everybody wants a lunch break. Everybody wants a morning and afternoon bathroom break. And I've had situations where someone passes away and the judge says, I got a break at 2 o'clock so I can go to Jim Smith's funeral this afternoon.
Right.
Yeah. But, in arbitration, again, the same thing could happen, but, you typically have a whole lot more flexibility in arbitration.
Probably in the number of hours in the courtroom are probably 20% more, maybe even higher than that in an arbitration. One of the things that I'd be trying the case here in Cobb Superior Court. I'd be trying the case, and my administrative assistant would come in, and she knew that it had to be important to come in, but let's say the Chief Justice, you had mentioned the Chief, let's say the Chief Justice was on the phone. Well, I'm leaving the courtroom and coming in chatting with the Chief, because maybe he wants to appoint me on a committee or wants to do whatever, but whatever he wants, even if he wants to fuss at me, he said, you weren't at this meeting and I thought you ought to be. I'm going to be listening to the Chief Justice. And then sometimes you just have emergencies. You have hundreds of cases and you've got a huge emergency, and you have to get off the bench. I tried not to do that. I tried to just, the administrative assistant would say, the judge is getting off the bench at 5 o'clock. We can arrange something early in the morning. He's an early riser. We can get something, or you can come in and have a 10-minute hearing tomorrow morning at 8 a.m. This was pre-COVID. And I know it's frustrating to the lawyers. It was frustrating to the judge. Typically in jury trials, we just didn't it had to be basically, an earthquake for me to get off the bench. I mean, we had all these people, and but you're right. You take a lunch break, and you take a couple breaks, which of course you would take. What you would take, and you may get 6 hours out of a regular court day.
Well, Judge, talking about arbitration, so if the parties want to go to arbitration and their lawyers say, let's do this, they reach out to Jim Bodiford, work out dates and all that sort of thing. Now, you're typically going to want a pretty comprehensive order appointing you as arbitrator, talking about rules of evidence and timeline and so forth. Is that typically the way you like to do it, or how does that kind of the logistical end of getting set up as the arbitrator for some folks?
They normally the lawyers will have already agreed they want to arbitrate. They have then decided they want me to arbitrate it. They would call me, one or the other would call with everybody's permission, or maybe email me and say, would you, we need for you to take 6 hours on this, or 2 days, or whatever. Would you accept the appointment? Would you accept the appointment? Would you, they would tell me what type of case it is. It might just be the one that I'm issuing an order tomorrow is just assets. They're older, their children are grown. They would tell me a little bit about it. If it's, most of the time, the lawyers who contact me are very good lawyers, and I'm going to say yes, and this is when I can do it. Maybe I'm so booked up that they just can't get in when they want to get in. But we try to book some time where we won't have to in recess. If they tell me 2 days, I'll probably arrange 3 days, because that's what it will take. Right. And then if we don't work the third day, fine. I'll actually have a day off in retirement. The judge will then issue an order. The lawyers would typically prepare it. Often it will say, we're going to follow the law, but we can use relaxed rules of evidence, and then the lawyers tell me, look, how do we want to do it? I've never had, in an arbitration, I've never had lawyers to tell me, we're going to run it. We're going to object to everything that possibly could be objected to. In other words, we're going to follow the rules of evidence right to crossing the T. If we want to do that, I'm well aware on how to do that. I've tried many cases, but typically in an arbitration, they're going to say, we're going to relax it a little bit. And we talk about, maybe you had talked about an expert in a custody case. You might talk about, hey, maybe we'll bring this expert in because they're normally charging a lot of money. Maybe we'll bring them in the middle of somebody else's testimony. And, and the lawyers agree, or I might suggest something. Can we relax this? Can we, do you agree on his credentials so we don't have to spend 10 minutes, arguing about credentials? We try to get things done ahead of time. The one nice thing that I think is good for the litigants is when we finish the case, like for instance, the case that I'll be ruling on tomorrow, that I'm just working on I'll work on my final draft today after I leave the courthouse on my private time. I looked at every piece of evidence, over 100 pieces of evidence. Now, some arbitrations might have 5 pieces of evidence, but I looked at every piece of evidence. Now, some were not that important. I looked at every one of my notes, 70 pages of notes, 2 or 3 times. I have the time to be able to basically, do a very thorough job. Now the litigants pay for the time, and they know what it's going to cost ahead of time. So you would say, well, if you're looking at the webcast, I've got to be rich to do this. No, you don't. It helps if you have a lot of money. Yeah. We've always heard about the Hollywood justice. None of the celebrities go into the regular superior court. They all go to retired judges or whoever. But no, middle income cases can do this too. And it may actually be more cost effective, because if you have to sit around, I don't know how it's going to be post-COVID, but I know how it was before COVID. You all arrived at a calendar call, and if you weren't the first case up or the second case up or the third case up, you were sitting there either outside working on your case or maybe listening to the case the judge had, and the lawyer is getting paid. That's what he or she gets paid for their time. Unless they could be working on another case. They typically had to be there, so if the judge was ready. So it may actually be more cost effective, but it does cost money for arbitration because you're paying a private arbitrator, and that's one additional expense that you don't pay when you come into the courthouse.
But again, Judge, in my experience, what they're paying for you as arbitrator is it's a drop in the bucket compared to the total attorney's fees. And typically it's going to be spread between both sides, 50-50. Now there may be a contrary agreement about how to split your fee as arbitrator, but goodness, if you're talking about 2 or 3% out of the total bill and you can get it done when you want it, as you want it done. Because I know one of the things you had said earlier was it's a kinder, gentler way in arbitration. And as you've seen, and I've seen so many times, when mom and dad go to court fighting over custody, if they had the possibility of being able to co-parent together, having a knockdown, drag out custody fight can really erode that ability to cooperate as each side is getting crucified on the witness stand. Whereas if it's done in a more relaxed, more comfortable, less hostile situation by an arbitration, you may actually stand a much better chance of preserving the ability to co-parent going forward.
I don't think you can say it any better than you just said it, because you're exactly right. I thought about this. In some cases, you have conduct that you don't want to, you don't want to share with everybody. For instance, when you were appearing in Zoom in the Cobb Superior Court, it's often out on YouTube. So, who's watching it? I don't know. But I will go ahead and give you a secret. I'm a pretty boring individual. And so last night I stayed up past my bedtime. It was about 9:20. And I normally go to bed about 9. And I know people are going to say, boy, he must really be old, which is probably true. But, you just don't want to share some things. And certainly, in an arbitration much more private, you can't, it's not in a public courtroom where anybody can come in, including your nosy neighbor, and hear about you smoking pot, whether you just did it yesterday or whether you did it back in college, which was 35 years ago. Because in a custody case, every bad thing is going to come out, which gives you the result you were talking about. I can't believe that he brought that up. That happened 35 years ago, and that's why I hate him. And that's why, probably he'd be a horrible father and we should never see the kid again or something. So I'm not saying if you have a custody fight, I'm not saying that everything's going to be hunky-dory when the judge issues the order or the arbitrator does, because it's not. At the same time, it can be a kinder, gentler. And certainly in an arbitration, when I'm dealing with custody, I have more time to talk with the parties. I can say to them, don't be like some of the litigants that I've had to come in front of me, where their daughter has to decide which parent comes to my wedding, because I can't have both of them there. And in my personal case, you don't need somebody who's been through a divorce, but I was divorced in 1979. I'm not that proud of that. I was 30 years old. We had a child. I was even though I was a lawyer in 30, I was pretty immature, frankly. But one of the happiest days of my life is when I'm sitting by my ex, decades later, and our son is getting married, and we're joking about how successful our son has been. And of course, I'm saying to her, at one point, even the preacher had me hush me up there. It was like I'm saying to her, it's pretty obvious that he's been so successful, 85% because of me and 15% because, but I mean, we're able to joke and be proud of our son, Whereas I had a case the other day, was not an arbitration, but I had a mediation where I had to tell the dad his son had gotten married in a ceremony that he didn't know about. I know that's a whole different subject, and I'm talking to you, and you're an expert in this, but we can see how things can go south so badly, and an arbitration hopefully can mitigate that. And again, every once in a while, like you were talking about, where they come out with an agreement, and probably only 20% of the cases. But look, 2 out of 10, I'll take that any day when they're in there for the fight and they walk out. Every once in a while, you get them shaking hands. You get them shaking hands and talking about, hey, let's go out for a drink, or I'll see you at church, or sometime in the future. My guess is they don't, but at least they were talking about it.
Well, Judge, we're getting close to our time to wrap this up. I just wanted a couple of last things to ask you now. Are there any tips that you want to share with folks who are going to arbitration, maybe that they can start thinking about? If you as an arbitrator see certain things that don't happen or that do happen and shouldn't happen, or any other thoughts that you might impart with folks who are heading towards arbitration?
Well, I would say this in any case, and certainly it applies in arbitration. I think judges, arbitrators, people that are making a decision are much more interested in a positive plan. Let's take a custody case, and but those are our hardest cases. But I'm much more interested, say, if the father wants to be the primary custodian, tell me what you can offer. Tell me what you can offer, rather than what all the deficiencies of the wife are, because you've already probably told me that 7 times, And that's what I'm interested in now. Look, if somebody has somebody has a drug problem and they don't pick up the child, or it's dangerous, or they drink and drive, or certainly we want to hear that. We want to hear that. But often it's last season we had 21 soccer games, and he only appeared at 19 of them. He missed 2. That's just, I want to drive the knife in a little bit more. That's not something that helps me. But I would, if I'm getting ready to go through a divorce, and number one, I would say certainly go out and mediate your case. Now, by the way, cases can be resolved without mediation. You've got good lawyers. A lawyer will tell you, hey, I think this is the range of your case. That the client says, I think I can live with that, and and you don't ever have to see the inside of a courtroom typically. But let's say your case is going to trial. You're going to resolve. I would really look at arbitration. I would say, hey, is this something? What are the benefits? And really, there are probably 2 things that I would say to somebody if they say, why wouldn't I want to go to an arbitrator? Well, number one, when I make my decision, it's going to be fine. It's not going to be reversed. And that doesn't mean that it could never be reversed, but I'm going to just tell you it's not going to be reversed. I can also tell you this. I've been reversed in criminal cases and in civil cases. Sometimes correctly reversed. Sometimes I think the higher courts got it wrong. But that's all right. They have a right to do that. They have a right to do that. But I've never been reversed in a domestic relations case in 37 years. The reason why is they give the judges great deference. And, we have great deference. So if you go to an arbitration, you're pretty much, even though you had a right to appeal, what does that really mean to you? But you're giving that up. You're going to give that up. And 2, obviously, you're writing arbitrator a check. Now, you've shown earlier, hey, you may actually come out better, but you're writing the arbitrator a check. But you can pretty much control the process, because the process is going to be agreed upon. When you come into the courtroom, I often say, how do you want to do it? How do we want to proceed today? And they tell me, and then I tell them how we're going to do it. In an arbitration, unless they come up with some crazy plan, we're going to do what they say. So that, we're going to work from 9 to 11, and then we're going to take a 3-hour siesta. No, that's not going to happen. But, I'm out there and I'm trying to work, and typically we're all on the same page, or the lawyers and I are all trying to work together for the benefit of the clients to make it as easy as possible.
Great, Judge. So just as we wrap up, Judge, What's the best way if someone wants to reach out to you to have you arbitrate or mediate a case? How do they do that?
Well, I don't have I think we talked about it earlier. I don't have a website. I've just been very lucky and retired. I've just been busy, busy, busy. My wife said, I think you're busier than you were when you were working. I said, well, I said, I'm very gratified that people want me and trust me. And it's given me, I've just been excited about my retirement and been excited about doing it and helping people. I feel like really that I'm what I wanted to do when became a lawyer in the 70s. I wanted to help people, with the additional knowledge that you have. So, I'm at the courthouse. You can always call. People actually still remember Senior Judge Bodiford, and they'll get in touch with him. I'll typically give you my private email, and you can contact me. I don't do any ADR, any alternative dispute, unless there are lawyers involved. So I don't, if somebody wants to do it without a lawyer, that's fine. The Constitution allows you to do it, but I'm not comfortable in doing that. And and then about in my retirement life, every 2 months, I try to take a few days off. I work one week of those 2 months typically, and then about 6 weeks, I'm doing this every day. I'm doing it every day. Now today, I just want to point out, I'm actually doing it from the courthouse, but I'm doing it on my lunch hour. So, but I think this is a public service anyway to tell people, hey, you can arbitrate, and there's not one judge upstairs. Since I retired, they moved me downstairs to the 4th floor, and I'm perfectly fine by that. But there's not one judge upstairs that if the lawyers come and say, hey, we'd like to arbitrate the case and we're going to take it to so-and-so, that judge is going to say, give me the order, I'm going to sign it, because they've got too many cases. If they didn't have enough to do, they might say, no, I think I probably need to do it. But if the parties want to do it, they'll be 100% for it.
Right. All right. Well, Judge, thank you so much. We'll wrap up now. I'm Bill Gentry here with retired Cobb Senior Superior Court Judge Jim Bodiford, who has been very generous in his time in talking with us primarily about arbitration, but also about mediation and other alternative dispute resolutions. Thank you so much. Have a great day, Judge.
Thank you so much.